Okay, so let's continue our discussion of directors. In our previous class, we discussed removal of the directors as well as restraining directors who have become disqualified from holding or continue to hold office as directors. Now, with respect to removal of directors and the provision that we look at session 176, we made the point that the law seeks to strike a balance between the right of members of the company to remove people that they have lost confidence in running affairs of the company. At the same time, because of the likelihood of abuse of such a right or such a power, the law also seeks to safeguard the right of the director or the directors to be removed from office, to fairness, especially the natural justice principle of Ordo Alteram Partem, that whatever allegations are going to be made to get other shareholders or members to cast their vote in respect of the ordinary resolution for the removal. The affected director or directors should be given the opportunity to also explain their side of whatever allegations are made before a decision will be made to remove them. Then again, we also discussed section 177, in which the point was made that a person might have been appointed the director and subsequently an evidence comes up that he or she is not qualified to be a director. It be either because he has been convicted of certain stated offenses, or he has even been a subject matter of a bankruptcy order which has not been vacated and so on. Now, you could go to court and get the court to look into it and make the necessary consequential orders. If the court is satisfied that the allegations made are true, then certainly the court could go ahead and make an order either imposing a ban on the person for being a director for a stated period, or even completely banning the person from being a director and so on and so forth. So where that happens, obviously, there's going to be a vacancy. And that is also another example of what we call casual vacancy, because it is a vacancy which has occurred in the directorship position before the expiry of the usual tenure or the usual term of office for that particular directorship. And that is why it will be a casual vacancy which will need to be filled. Now, just before we leave what we did the last time we met, the other point to remember is that we also said that the law has created an obligation for the person who has become disqualified not to remain silent. You need to own up and come forward and say that I've become disqualified. And if circumstances have arisen, by which reason you have been brought within the categories of instances in which a person is disqualified to be a director, and yet you keep your mouth shut and continue to hold on to your position as a director, you will have committed a criminal offense. Yeah, so that is what we discussed the last time. Now, tonight, we want to continue to look at certain kinds, certain types of directors recognized by the Company Act of Ghana. And of course, not only in Ghana, if you go to so many other common law jurisdictions, whose law is somehow in pari materia as ours, you have equivalent provision. So first, you want to talk about substitute directors. So substitute directors versus alternate directors. So we'll be looking at section 180 as well as section 181 first before we move on. So who is a substitute director? Who is a substitute director? Now let's get the concept before we look at the law itself. A substitute director, of course, in football, if you say that somebody is a substitute, you know what I mean. But the way that the word substitute is used in relation to directors is a bit strained in the sense that the meaning is probably more than how it is used in everyday sense. Because in football, well, I'm not a great football guy, but at least the little I know about football is that if the match is being played, hey, by the way, what happened to the Barcelona and did Barca win or lose? Okay, you are not following.
They drew.
They drew.
They drew.
Draw.
All right.
Yeah.
Please.
All right. My daughter will be sad. My daughter supports Barca. She was watching, but I was doing something else. Okay. All right. So if you take football, for example, those who are not playing, they were on the bench and the what we call like the substitute. But they are not a substitute for any particular player. I stand to be corrected, but that's my understanding. That the substitute on the bench, they are not for, let's say, a particular player. Depends on what the game plan may be and so on and so forth. But then when it comes to directors in company law, what happens is that if you look at section 180, right, section 2, what happens is that a substitute director is one who is appointed to act as a deputy for another named director and as a substitute in the absence of that director. So the substitute director is, as if you like, a standby replacement, as it were, for a particular director, for a named director. So that anytime the substantive director is not available, the substitute director will actually come in to exercise all the rights and powers and functions which the substantive director would have exercised if he or she were to be available. So that is a substitute director. So simply put, in terms of section 180, subsection 2, a substitute director is one who is appointed to act as a deputy for another named director and as a substitute in the absence of that director. So a question may arise, can anybody, any company at all, appoint substitute directors? And according to section 180, subsection 1, the answer is yes. And that is why 181 says that, except as otherwise provided in the constitution of a company. So except as otherwise provided simply means that, as a general rule, what follows in this provision holds true. However, it is possible for a company to disable this particular provision or to modify its operation, right? So where the company has not stated anything to the contrary in its constitution, assuming it has a registered constitution, then the position of the law is that the company has the discretion, has the freedom to appoint substitute directors in accordance with this section. So look at it. It didn't say that to appoint a substitute director. It says substitute directors. That would say that if the company has got, let's say, 7 directors, and the company is interested, it can probably appoint another 7, so that each director has got a substitute, or it can probably appoint 3, be a standby or substitute director for directors who have been named. But the point to remember is that a substitute director should be for a specified, that is a named director. It's not just a substitute at large, right? Or just a floating substitute, no. He is a substitute for a particular director, as the case may be. And again, if we look at 183, where the law has provided that you need a certain number of directors to do something, right? Either you need a certain minimum number of directors, or you need a certain maximum number of directors for certain purposes, including a quorum. And because we've discussed the law of meetings, you know what the quorum is. Quorum refers to the prescribed minimum number of members eligible to attend the meeting who must be present before the meeting lawfully commence and transact business. So that is a quorum. Now, where you have a substitute director, the substitute director is not counted. Anytime we need to find out whether the required number of directors has been met for certain purposes. So that is the point. So the substitute director is not counted. The only time it will be counted is in relation to meetings, quorum, right? Like, so that is the only exception. And of course, it makes sense that he's a director for a substitute for a named director. So if the named director is absent and is going to attend the meetings, then if we need to find out whether quorum has been met, it makes sense for him to be counted. That is why Section 183 is saying that the substitute director shall not be counted as a director for purposes of a provision in this act or constitution of a company prescribing a minimum or maximum number of directors, other than a provision relating to quorum, right? So the only time we will count a substitute director, if we like, in his own right, is when we want to find out whether quorum has met. But apart from that, all other instances, if the law says that you need a certain number of directors to do something, and a substitute director is present, we don't count the substitute director. So let's keep that in mind. Again, if it happens that the principal director, okay, if I say principal director, that is the substantive director, the particular director, whom the substitute director has been appointed, right? If he is present at meetings, then the substitute director cannot vote. The substitute director can be at the meeting, all right, will be contribute to discussions and all that. But when decision is being made and you need to cast vote, because his principal, his substantive person, he cannot vote. So look at section 180 subsection 4. But it is important to remember that all the things that we have learned about directors, right, in terms of qualifications, in terms of disqualifications, in terms of appointment and then removal, which we have discussed so far, they are applicable to substitute directors, mutatis mutandis, or with necessary modification, as the case may be. So therefore, what someone should meet to qualify as a director is no different from what a substitute director should also meet. So that's the point we are trying to make. And again, that which will trigger removal of a director from office, as we have discussed, is the same for a substitute director, right? But The other point to note, which is in section 186, is that the mere fact that the principal director, that is the substantive director, at whose instance you have been made like the substitute, or for whom you be appointed as a substitute. The fact that the substantive director has ceased to be a director does not mean that a substitute director is going to automatically cease to be a director. So let's keep that in mind. And what do you mean practically? So let's say that Charles is a director, and Dauda has been appointed a substitute director for Charles, right? So Charles is the substantive or the principal director. Now let's suppose that for whatever reason, oh please, whose mic is on? We are getting, let me see. Samuel J. President, why? Yeah, so if the principal director, in this, I think the example I was using was the Charles and then the Dauda. So Charles is the principal, like the main or substantive director, and then Dauda is a substitute, right? Now let's suppose that Charles is removed from office as a director. Then according to section 186, which says that a substitute director shall not cease to be a director. So Dauda shall not cease to be a director by reason of the fact that the director for whom that person is a substitute, in this case, Charles, ceases to be a director. So let's keep that in mind. So if the principal is removed, the substitute will still be there. Maybe the company may probably go ahead and then tie that substitute whose principal has been removed to another substantive director, as it were. Now, the other point to also note is that a substitute director is not appointed by the principal or the substantive director. So just like the example that we had, Charles as a principal director and then Dauda as a substitute director. It is not the case that Charles will tell the company that, please, let me appoint Dauda as my substitute. No, that is not really the case. It is the company itself which will go out of its way to say that we are going to appoint Dauda to be a substitute for, let's say, Charles, as it were. And that has implication because the substitute director is appointed by the company has the burden to provide remuneration, to provide emoluments, allowances, just like the substantive director. Now, very soon, when we are discussing alternate director, you notice that alternate director will not be remunerated by the company. It is rather the particular director at whose instance the alternate director was appointed, who will have to actually arrange for emolument or remuneration of the alternate director. So let us keep that in mind. And maybe if your examiners want a very straightforward question, students can be invited to draw certain distinction. Let's say substantive director and the alternate director, so you should know what to tell your examiner. Good. So who is an alternate director then, having known a substitute director? Well, an alternate director conceptually is a director who has been appointed at the instance of a substantive director for a specified period, and usually not exceeding 6 months. So let's look at the law itself and analyze the provision. Section 181. except as otherwise provided in the constitution of the company. So you notice that we saw the same chapeau or the same preamble, right? When we're discussing section 180. So except as otherwise provided, we explained that means that is to say that what is going to follow in the provision is applicable to all companies. However, it is possible for a particular company to disable the applicability of that provision. So, except as otherwise provided in the constitution of a company, a director may appoint another director or any other person approved by a resolution of the board of directors as an alternate director who acts as a director in respect of a period not exceeding 6 months in which that director is absent from the public or unable for a reason to act as a director. Yeah, so a few points to note from section 181 is that the alternate director is appointed not by the company, it's appointed by a particular director. That is one point to note. And then another point is that the particular director who is appointing the alternate director will need to get approval by the board of directors. So the board of directors will have to approve whoever you are appointing or recommending for appointment as alternate director. And again, situations in which it may be necessary for alternate director to be appointed according to section 181, subsection 1, include if you are going to be absent from Ghana, right, for a period not exceeding 6 months, or for whatever reason, you are not able to act as a director. Either you are sick or you are so busy with some other commitments, you can appoint alternate director. So let us keep that in mind. And I think we have mentioned the case of Politis and Plastico. Politis and Plastico, and we've mentioned that the fact that, and then also the case of what do you call the Okujeto and then Iran brothers. We've made that already. Now I trust that you have read it, at least just the facts to remind you or to give you a practical sense of how alternate director, for example, is appointed, and then he will need to get approval or endorsement by the board of directors, as it were. So let me give you, just in case you haven't read it yet, please go and read it. Let me give you the Okujeto. I'm not talking about the new politician Okujeto Blakwa. So don't go and write Okujeto Blakwa, right? This one, Okujeto, they're referring to like the lawyer. It's a very old Okujeto and Iranian brothers. In 1974, one Ghana law report. '81. Yeah, so Okujeto against Iranian brothers. 1974, one Ghana law report 381. And there was this issue as to where you recommend someone, or where you are substantive director and you bring someone to be alternate director. So if the board of directors should say no, should that be interpreted as they trying to oppress you as a member or as a director, as the case may be? And in the context of that, Mr. Justice Benjamin, as he then was, will make the point that, and I quote, the refusal of the directors to accept the applicant's attorney as an alternate director cannot also be impugned. And then he cited the section 1881, which is equivalent of the current section 180. I mean, he cited section 181, which is equivalent of section 181(1) of the present law. And he continued, the court continued that the attorney was not a director and there was no resolution of the board approving him as alternate director. Neither he nor the applicant can therefore complain. Good. So the point reinforced by the ratio of Okujetu and Rani Brothers is that if you are appointing alternate director, need to get the board of directors to actually approve it. If they don't approve it, then, what it means is that you have not met the threshold. Of course, this decision is not final pronouncement. Whether Victor Mensah, please mute yourself. Victor. This decision,
thank you, sir. Thank you, Doc.
Right. This decision is not like a final pronouncement, right, as to whether in all instances, if the board of, you bring, let's say that you brought about, you brought one person, the board said no. You brought another person, the board said no, and so on. Sometimes, of course, if, assuming, let's suppose that you are a member at the same time, you know that, and you think that there's some kind of conspiracy, right, to put stumbling block in your way. Of course, it may be possible for you to get a legal remedy depending upon the particular set of factual scenario. So let's keep that in mind. Now, the other point to also remember is the mode of appointment, right? How do you appoint the alternate director? So section 181 says that the appointment shall be in writing, signed by the appointor. The appointor here refers to the substantive director who wants to appoint someone. An appointee is the prospective alternate director, and lodged with the company. So that is very important. So you don't just go to board meeting and then tell your colleague board of directors that, okay, for the next 3 months, I'm going to be unable, I'm going to be away. So I want a Joa, or I want a Quia, or I want Ya or Sewa to be my alternate director. No. If you do that, you haven't brought yourself within the strict requirements of the law in terms of mode of appointment, because the law is quite clear and it unambiguously makes it clear that you must put it into writing, get appointed to also do what? Also sign, appointee sign, appointor sign, then you send it to the company. Now, where you have been appointed alternate director, for the period that you are going to be alternate director, for all purposes, you are considered a director, an officer of the company. And let me emphasize, and that is a point about section 181 subsection 3A, that the alternate director is not an agent of the appointer. You've done commercial law, you remember your law of agency, and of course, also by the Power of Attorneys Act, where you can appoint someone to represent you in transactions and all that. Now, on the face of it, if you have alternate director, it appears that he's your agent. However, it works differently as far as directorship is concerned because of the onerous responsibility associated with the position of directorship. And that is why we are being told by section 181 subsection 3A that the alternate director is not an agent of the appointer. Despite the fact that you are appointed by the appointer, you are not his agent. I mean, you are not his agent, or the appointer is not your principal, as it were. Now, what does that mean, legally speaking? That is to say that when you are exercising your duties, your roles, your functions as a director, during the period that you have been appointed alternate director, you cannot be heard, right, to say that I did X, Y, Z because my appointer said that that is what I should do. No. You have fiduciary obligation as a director. And as you notice very soon, we are discussing duties of directors. So as a fiduciary, you have a duty of utmost good faith. You are supposed to exercise independent judgment. And for that matter, during the period that you alternate director, if anything should go wrong, you have to bear personal responsibility. The principle of vicarious liability associated with the law of agency will not apply to relieve you of legal burden or legal liability. And that is the point about section 181, subsection 3A. And so let's keep that in mind. Another point to note is that when you are appointed alternate director, you are, as please, Seth, put off your video. You know, when you are doing Zoom meeting, be careful about your videos, right? Especially when the session is being recorded, because sometimes you don't know what you may expose, okay? Good. I could put on my video, I'm in my study room, but I switch it off. Yeah, so
My Lord.
It's okay, let's continue. No comment.
My Lord.
Yes.
I would like to ask a question with respect to the 6 months appointment.
Okay.
I would like to know that if in the course of the year, the substantive director had to be away for 6 months, must he do the nomination and the writing?
Yes. Yes, you go through the same process.
All these cases, all 8 of it.
You go through the same process. So if it's going to be even be 4 or 5 times, you have to go through the same process. So it's not the case that, let's suppose that it's not the case that I appointed you as alternate director. Okay, I was away for 4 months. I've come back to Ghana. I work for 2 months. I need to, be unavailable. I need to go out of Ghana. And so I need you to be alternate director. Then can I just tell the board of directors that I'm standing by my previous appointment? No, you have to repeat the process. That's my understanding of the law.
Thank you, sir. So by this, I may take it that when the director returns to the board, is that the case?
Sorry?
I was asking whether or not when the substantive director retains from maybe the 3, 4, 5 months absence,
all right.
a notification must be given to the board to that effect. Is that the case?
Oh, sure. But if you look at the law, it's not, like as soon as you come back, automatically, once you are there, the appointer, because he is supposed to act in your absence or when you are not able to be there. So once you are present, automatically, his appointment will be in abeyance or to come to an end. So that it will not be the case that I appointed you alternate director, right? Let's say for 5 months, and I spent only 2 months, and I have come back. So I go to meeting, you are there, and then you, the alternate director, you insist that, well, you appointed me for 5 months, so I don't really care that you are back. I'm still waiting to serve the rest of the, of the term. Now, if you bring what you call the cursive interpretation, right, approach to bear on the provision, a better understanding will be that the alternate director is, if you like, a stopgap measure. It is a convenient arrangement to solve, if you like, unavoidable absence of the director. So if that is the case, if the director who previously was unavoidably away or absent says that I am now present, I am able to exercise my functions, why do you insist that you should be allowed to exhaust the particular period? What do you think, class?
So I think that will be very deadly, because once I'm there, the appointee should not be there. So why would you want to stay there, despite the fact that I've returned back to my usual routine?
Yeah, okay.
I also think that because you are an alternative director, when it comes to voting at the meeting, you cannot vote. So why are you there? If the person has come.
Okay.
And so I also believe that once the substantive director is the one who appointed you, and you were approved by the board, when he's back, it is appropriate that he takes over from you rather than you staying on whilst he's back.
Okay. Maybe there is a remedy which but of course now we are going to reason outside company law and probably come to some other area of the law. Maybe between the appointer and then the appointee, right? The alternate director and then the substantive director. If, for example, you appointed me for 6 months, and then just after 2 months, you come back and you say that, thank you, my alternate director, I am back. So I want to resume my duties. Thank you, bye-bye. Then the alternate director says that I have ordered my life, I have ordered my affairs to take care of the 6 months that you are giving me. And for that matter, I have what we call legitimate expectation that for the next 6 months, I was going to be your alternate director. And by so doing, certain other things which I could have had, I'm not going to be able to pursue it because I've already adjusted my schedule and all that. So maybe between the two, probably within a law of contract, because don't forget the arrangement between the appointee and the appointee is really contractual arrangement, isn't it? And that is why both are supposed to sign a document and all that. It's sort of like a contract between them. So probably an argument will be made that the appointee may be able to bring up a claim against the appointor in a situation like that. Good. So the other point to also note is that if it is a requirement that a director should have shares, that qualification will be excused in the case of rotating director. Now, in the case of a substitute director, that requirement is not excused, because when we discuss section 180, the law was silent on share qualification, meaning that if it is a requirement that a director should have shares in a particular company, and you appointed a substitute director, you need to meet that requirement as well. But in the case of an alternate director, section 181, subsection 3, paragraph B, is quite explicit that even if directors in the company are supposed to have shares, the alternate director need not meet the share qualification as it were. So let's keep that in mind. And again, an alternate director cannot appoint an alternate director. I'm sure you've heard delegatus non delegare quitus. You know, an agent cannot appoint, yeah. So, but of course, as someone who said that not long ago in section 1813A, the law is quite emphatic that the appointee is not an agent of the appointor, meaning that the law of agency, strictly speaking, does not apply to the situation between the substantive director and alternate director. So if that is the case, why are you bringing another agency principle? Because this delegatus non-delegare quitus is actually a principle of the law of agency, isn't it? Nevertheless, that is what the law says, that an alternate director cannot appoint an alternate director. But of course, it makes sense that someone is saying that I'm unable to exercise my office as a director, I'm appointing you. Then just as you're appointed, you also tell the board that you're also appointing someone. The matter is you are used as alternate director. And again, just like the substitute director, where we're told that where the law has prescribed maybe a certain number of directors for certain purposes, we will not count the substitute, the alternate director. The only time we count the alternate director is if we need to determine whether quorum has been met for purposes of a meeting. So that point is similar to a substitute director. And then we come to a very crucial aspect. Now, section 181.4 is also clear that the company is not liable to pay additional remuneration by reason of appointment of alternate director. So alternate director appointment is a private arrangement between the substantive director and then the alternate director. Despite the fact that the board of directors will have to approve it, but it's still a private arrangement. And what that implies is that the emoluments, the allowances, remuneration, whatever, the perks which go with directorship will not have to be met by the company. It is the particular director who will have to arrange that. Either you give all your allowance to the person, or you give a portion of it, or whatever. That's your private arrangement. But in the case of a substitute director, as we notice, remuneration, emoluments, salary, and all that is the duty of the company and not the duty of a particular substantive director.
Hello, sir.
Yes, but the other point to notice is that if you look at subsection 6, it's contemplate a situation where maybe unless, if you remember, the company can, make, some special, provision regarding how he should be remunerated, and probably say that we are going to take the money which ought to have been paid to the main director to you. Probably the company could put that in its constitution, or where the company's constitution is silent on that, then it is a matter which will have to be sorted out between the lieutenant director and the appointing director, as it were. And just before I let the questioner, yes, somebody wanted to ask a question. Let me hear you, please.
Okay. So my question is on the counting of the lieutenant director and the substitute director when it comes to quorum.
Okay.
So assuming that the substitute director appointed in the name of a particular director also has appointed an alternative director. When it comes to quorum counting, are we going to count both since they are representing one particular person?
Let me understand. So you are saying that a substitute director has appointed a lieutenant director. Is that the case?
No, a substantive director
Okay.
has appointed an alternate director.
Yes.
Good. And then we also we know that the company might have a substitute director in respect of that particular director.
Okay, all right, good. Understand you now. Okay. Now, see, the way things are, practically, where the company has a substitute director, it may never be necessary for alternate director to be appointed, because the alternate director is stepping in for the period that the substantive director or the appointed director is unable to act or is away from the public, not the same 6 months. So if you have a substitute director, he is also supposed to come in when the substantive director that is a substitute for is not present. So what the alternate director is doing is the same thing that the substitute director is doing. The only difference is that the substitute director is appointed by the company. The alternate director is appointed by a particular director. And again, the position of the substitute director is a permanent position, so to speak. But the position of the alternate director is not permanent. So that, I mean, that is it.
Hello, sir.
Yes.
Yes, sir.
Sir, please, I want to find out the policy rationale for the appointment of the alternative and then the substantive director, substitute director, other than for the purpose of a quorum.
Oh, that, okay, good. Now the policy rationale for substitute director and lieutenant director, let's start from the fact that you need a certain number of directors to do what? To exercise the position of the directorship. However, human beings as we are, please let your mind be obviously like somebody is snoring or something, or there's a wind. Right, thank you. Yeah, so human beings as we are, circumstances would prevent someone from being available, and the work of directors should not suffer. The work of boardroom activities should not suffer. And the meeting is, if you like, the very crucial aspect. Because meeting, of course, if you also look at the law was actually set at a time when technology had actually not made progress as we have it now. Because in my view, now you can have, I mean, look at the class you're doing online class. We have about 30 or 40 people scattered in different locations. And I'm also somewhere. The same thing. So the same platform can be used for a meeting. But if you go back into the history of the law, this law had just been, just if you like a copy paste. You just carried it from the old legislation, Act 179, made in 1963. And that legislation was also drew inspiration from the 1907 Companies Ordinance. So at the time that the law was made, understanding of meeting, understanding of interaction was mainly physical. But for now, if you really want to be very critical, an argument will be made that it may not even be necessary to appoint, if you like, alternate director, as it were, especially so if you are having meetings virtually, except where the person condition is such that even if you are having meeting virtually, he still is sick and so on, he can still not participate. Then that one is a different matter. But the wisdom behind it is that the unavailability, be it physical or sickness or whatever reason, of a director should not impede governance of the company, which is done by directors. And that is why that mechanism is there. Okay, so let's move on. So let's look at the 7, that alternate director who is personally director shall have an additional vote for each director for whom the alternate director acts as alternate director at every meeting of the directors. Yeah, so it is possible for a certain director, right? You're a substantive director, and your colleague director would appoint you as his alternate. Now, where that is the case, then because you are a substantive director, if it comes to polling, when it comes to voting to decide the matter, by reason of being a substantive director, you have the right to 1 vote already. In addition to that, you also cast the vote, which the appointing director has, because you are his alternate director. So that is a point about subsection 7. And also, if you look at it, one director can serve as the alternate director for many directors. And that is why, and that is why you can also run into, if you like, a bit of complication. So sometimes, if you have a problem with form and substance. So let's say that we have 5 directors, right? And 3 directors, or let's say 4 directors are away. They're giving they've appointed you as alternate director. So you alone, you can have the meeting. You see how practically it sounds a bit incongruous, isn't it? Yeah, so let's look at the circumstances in which the appointment of alternate director will come to an end or shall cease. So let's look at section 181 subsection 8. And it has provided 4 instances, 4 scenarios in which the appointment of alternate director will automatically come to an end. A, at the expiration of the period for which the appointment was made. So once the period has expired, there's no need for the appointing director to tell the appointor or even to tell the board of directors anything. B, if the appointor gives written notice to that effect to the company. So the appointor is the one who appointed. If he tells the company that I'm back, or I no longer want to be represented by this person, that'll be it. Or C, if the appointor ceases for any reason to be a director. So if the appointing director loses his directorship in terms of the things we've discussed earlier on, then, as Lord Denning has said in the well-known case of McFall versus UAC, United Africa Company, that you cannot put something on nothing and expect it to remain. It will do what? It will fall. So, alternate director is premised upon existence of a substantive directorship. So, if the substantive directorship is no longer there, automatically the alternate director will also come toward an end. But if you remember, when we're discussing session 180 in relation to statutory directors, it was different. We learned that the mere fact that the named director for whom you are a substitute director has ceased to be a director will not mean that the substitute director has lost his directorship. So know the difference. In the case of alternate director, the substantive director, the appointing director, should have his directorship intact. Otherwise, the alternate director will lose his directorship. And then D, if the alternate director resigns by notice in writing to the company, of course, then automatically he has ceased to be alternate director. Yeah, but section 9 is very, subsection 9 is very instructive. So I would like to quote that for analysis. So 181.9, quote, until the cessation of the appointment of an alternate director, both the appointor and appointee are and may act as directors of the company. But an alternate director, unless personally a director, shall not attend or vote at a meeting of the directors or committee of directors at which the appointor is present. Yeah, so if the appointing director is present, the alternate director will have to pale into irrelevance, will have to disappear, so to speak. Unlike a substitute director can attend meeting even if the principal director is what? Is present, except that the substitute director will not have vote because the principal director is what? Is present. But in the case of alternate director, as section 181 subsection 9 is telling us that if you are just alternate director and you are not a substantive director in your own right, as we noted earlier on, that a substantive director could be appointed alternate director by another substantive director. Now, where that is the case, there's no problem because you are a director in your own right. So if the other party the other person who appointed you, alternate director is around, that in itself will not prevent you from being able to attend meeting because you are a director in your own right. However, where you are not a director in your own right and you were just brought in as alternate director, then if your appointing director is present, you cannot attend a meeting or vote at a meeting as it were. So let's keep that in mind. Any question before we leave substitute director and alternate director?
Yes, sir.
Yes, please. Louder.
Yes, sir.
Yeah, please proceed.
Please, sir, the alternative director, is it mandatory that that person should be appointed for 6 months, or it can be lesser than 6 months?
Oh, it can be lesser than that. It can even be for 1 month or 2 weeks.
Okay. Thank you, sir.
Welcome.
Hello, sir.
Yes, please.
Can you please take the subsection 9 again? Further explanation.
Yes. Can you tell us what you understand so that we know where you are not clear and we explain? What did you get from, like, what is your understanding? Let me put it that way. When you read it. It doesn't matter, say whatever is on your mind. I want to, so that we know what your problem is and we explain it.
Hello, sir.
Yes.
What I'm saying is that my understanding lies from the fact that the alternate director cannot vote when the substantive director is around. Is that the case?
Oh, okay. All right. Thank you. So, section 181, subsection 9 is speaking to, if you like, 2 scenarios, if you want to really put it into smaller units. First, we are being told that where the appointment of the alternate director has not come to an end in any of the ways that we have seen not too long ago under subsection 8.
Okay.
Now, both the substantive director, the appointing director, and then the alternate director, they are directors of the company, all right. However, there are 2 types of alternate director, if we put it that way.
Okay.
We have a substantive director, that is one of the board of directors, who has been appointed alternate director by another colleague director who is going to be away. We have that type of alternate director there. So where that is the case, should the person who appointed you director, let's assume that he's come back and is even not taking steps to terminate your appointment. Now, subsection 9 is saying that because you are a director in your own right, you can attend and vote at meetings. Because when you go, you are going to represent yourself. You're not going to represent the other person who appointed you as alternate director. On the other hand, if you were not one of the directors already, and then you were brought from outside as alternate director, then when your appointing director is present, you cannot attend meeting and vote at the meeting. So that is what subsection 9 is saying.
Okay. Thank you. I'm fine.
All right. Okay, so any other question before I move on to section 182, which is very straightforward. Okay, good. So in absence of questions, yes.
I have a question.
Yes, please.
Please, and this is Dauda.
Yes.
in relation to the substituted and then the alternate director.
Okay.
My understanding is that both can be counted in for the purpose of attaining a quorum at meetings.
Yes.
Quorum at meetings.
Yes.
And also, per my understanding, unless quorum is made in a meeting that decisions have been taken. So if a substitute director is being represented a substantive director, which has been counted to form a quorum, and if we come to voting, you cannot vote. Is there any legal reasoning behind? Because had it not been counted as a quorum, the law should have allowed you, because it means that you are going to represent whatever your substantive director is not there to do.
Oh, no. Let me, it's good you brought this up. Let me clarify. We made the point that in relation to substitute director, if the law says that we need a certain number of directors, purpose maybe either a certain minimum number or maximum number, we don't count, if you like, the substitute director. But when it comes to quorum, we count. Now that does not mean that if voting has to be done at the meeting, the substitute director cannot vote. He can vote, so long as the substantive director is not present. That is the point we are trying to say. If the substantive director is present, the substitute director cannot vote, because in that case, the substantive director. Hello, Sina. Yeah, sorry, I got a call. Yeah, sorry. Yeah, so that's about it. Yes, it's not just only for quorum. You can also vote. Now for alternate director, if the substantive director is present, the alternate director will not even count will not count for purpose of a quorum. So let's get it. It's not the case that even if the substantive director is present, we can't do for purposes of quorum, but then you cannot vote. No, that is not the case. Now, if you remember section 181 subsection 9, in the case of alternate director, it was quite strict that unless you are that type of alternate director who is already a director in your own right, and another director has appointed you as his alternate director, in which case his presence will not be a bar or will not be an impediment for you not to attend meetings, because you are director in your own right. But if you are an alternate director who is not a director already, but you were just brought on board by one of the directors, then should that person be present, you cannot even attend meetings. Yeah, so any other question?
Sir.
Yes.
Because the reason why I asked, when you look at the section 180 sub 4, says that a substitute director is not entitled to vote at a meeting of directors or a committee of directors at which the director for whom that person is a substitute is present.
Yes.
So that is why I'm asking the question. So per what you have explained, it means that
My Lord, can we use the 3 rather instead of the 4, because the 4 is straightforward?
All right, okay. The substitute director shall not be counted as a director for purposes of, is that what you mean? Is that a subsection 3, please?
Yes, please.
Yes, my lord.
Yes, please. Yes, my lord.
Or the constitution of a company prescribing a minimum or maximum number of directors other than a provision relating to quorum. Okay, so let's get this thing clear. First and foremost, let us remember that a substitute director is a permanent appointment. An alternate director is a temporary appointment. A substitute director is a permanent appointment, but is, if you like, a standby director for a name or a substantive director. So that is one. And because it's a permanent appointment, he's going to be paid by the company and all that. He can attend meetings, even if the substantive director is present. However, he will not have a voting right if the substantive director is present. And that is why subsection 3 says that in terms of quorum, he can be counted. And your question was, how can he be counted for purposes of a quorum, but then he is not given the right to vote? Is that not the question?
Yes, please.
Good. And as I said, unlike the alternate director, for alternate director, if the substantive director is present, he cannot even attend meetings because we saw that. The only exception is where he is already a director and then he's serving as alternate director in addition to that. But a substitute director is a permanent director. Like if a director is appointed, let's say for a period of 2 years, and you're appointed as a substitute director, you're also appointed for 2 years, except that unlike the other directors who are exercising the full gamut, the full spectrum of directorship all the time, in your case, aspect of your functions sometimes go into hibernation or be suspended because you are a reserve, so to speak, you are a standby for a named director. I don't know if that assists you.
Yes, please. It's okay, Doc.
Okay. All right. So let's before we go, let's address the principle of residence of directors in the country. It is the law that every company must have at least 2 directors. You've made that already. It is also the law that at every point in time, one of the directors of the company must be resident in the Republic of Ghana. And when we say resident, that is to say that he is based in Ghana. We're not talking about you just visit one and then you go. No. Now you may want to ask a question. What is the wisdom? What is the policy rationale or the raison d'etat underlying the provision in section 1A21 that at least one director of the company shall at all times be resident in the Republic? Now, don't forget that the company is artificial legal person, right? It's just a juristic person, artificial legal person. And as we noted from the dictum of Lord Cranworth in the case of Aberdeen brothers against the Aberdeen Railway against the Blackie brothers, that the company functions through instrumentality of flesh and blood, like the officers. So if, let's look at the situation where all the directors of the company, they're outside Ghana. You don't have even one in Ghana. Now, let's suppose that the company has committed certain wrongdoing, certain even statutory breaches and all that, including contempt of court, right? And you need to actually hold the company accountable. The company is just, it's artificial entity, it's a notional concept. You cannot touch it. So if all that the company has is just a registered office, and let's say that they even rent somebody's one room, and they just have a table and chair and then a computer there, that is all that you can get about the company. But the law may even lift the veil and say that for certain things, we are going to hold directors personally accountable. And where all the directors are outside Ghana, none of them is resident in Ghana, it will make matters very complicated, and it will lead to the corporate vehicle being abused. So to avoid abuse and people using the company to indulge in wrongdoing, perpetrate fraud on the public, the state, and all that, that is why it is the law that at least one of the directors of the company should be a resident in Ghana. And where that is not complied with, consequences will ensue. And that is why Section 182, subsection 2, will say that where there's a breach of that requirement, then the company and every director involved shall be amenable to pay administrative penalty units, which will be inflicted by the Registrar of Companies, as it were. So let us keep that in mind. Yeah, so I mean the rest are just telling us about the consequences which will happen where transactions are made during the period that none of the directors was resident in Ghana. Now, just before we go, I want us to clear the issue of the executive directors and the managing directors so that we know that we are done with the types of directors and we'll be left with just the discussion of the duties of the directors and remuneration. So let's take 10 minutes to quickly clear this, right? Good. So executive directors, who is an executive director? An executive director is a director who, in addition to being a director of the company, is also an employee of the company. I mean, that is a very simple way of conceptualizing executive director, that in addition to being a director, you are also an employee. But mind you, directors are not employees of the company, so to speak. Now let's look at the law itself. Section 183. Except as otherwise provided in the constitution of the company. Now, before we continue, I want to draw your attention to important legislative technique or device, which have been running through a lot of the provision. A lot of the provision, you see the opening preamble or the opening expression, or what you call the chapeau, that except as otherwise provided in the constitution of the company. So that is to say that the law is going to create a lot of general position, general principles, right? Which will apply to every company. But then, if a company does not want the general position to apply, then that company ought to have made special arrangement in its constitution, if it has a registered constitution. So, except as otherwise provided in the constitution of a company, A director may hold any other office or place of profit under the company, other than the office of an auditor, in conjunction with the office of a director. Yeah, so apart from you being employed as an auditor, nothing prevents a company and prevent a director from also taking any position in the company and being paid for it. So that is executive director. So executive director, any person who is a director, in addition to that, is able to take up position or office or employment in the company other than the position of an auditor and is paid. That is an executive director. B, the directors may from time to time appoint one or more of their body to any other office for the period and on the terms that the directors may determine and subject to the terms of an agreement entered into in a particular case may revoke the appointment. Yeah, so a director can be appointed, maybe director of finance, director of HR, or whatever. Now, his position as a director of HR or director of finance or director of operations, it is a normal paid employment position. However, his directorship is actually brought about by the company itself, by the members of the company, appointing him at meetings. So that one is not determined by the board of directors. So that the executive director or executive directors are wearing two caps or two hats. One hat is their directors appointed by the company through its appointing rules of directorship, maybe like the members in the general meeting, passing resolution and all that. And they have another hat. And that hat is like, they are also like employees in the company. But that employment position is not determined by the members of the company because it is the directors as officers who actually hire and fire employees or recruit employees on behalf of the company, as it were. So let's keep that in mind. Now, see, subject to compliance with section 185 and subject to section 214, that office will be remunerated by way of salary, commission, share of profits, participation in pension, and retirement schemes, or partly in one way and partly in another. Now, later on, when you go to section 214, you will notice that directors are being admonished that when they are exercising their power to determine remuneration for, let's say, their colleague directors who also may have employment, then they are not supposed to give what they call the tax-free payment. And so that is section 214. We'll go and discuss that later when we are discussing duties of directors. And then with respect to section 185, the rules on remuneration and other benefits of directors. When we get there, you notice that directors do not have the power to determine their own remuneration or their emoluments. It has to be determined by shareholders at general meeting. However, when it comes to directors who have employment, their employment remuneration is different from their remuneration as well as directors. And their employment remuneration is determined in the way that the directors actually recruit employees on behalf of the company. So let us keep that in mind. And that is why section D will say that when the board of directors are exercising their power, let's say to determine how much another director who has been given employment should be paid and all that, when they are exercising their power to determine that, they are reminded of their fiduciary obligation. They are reminded of their duty to actually have the interests of the company as whole in mind. So that is what sections 190 and 191 will tell us about. And finally, we have a particular type of executive director called managing director. And a managing director is also executive director, but if you like, a special kind of executive director, or executive director of a sui generis, so to speak. So let's look at section 184. Except as otherwise provided in the constitution of the company, the directors may from time to time appoint one or more of their body to the office of managing director. And section 183 shall apply to that appointment. So you see that is not very different from the executive directors, except that we are creating a particular type of executive director, so to speak. What do you call it? The managing director, the office of managing director. B, the appointment of managing director shall be automatically determined if the holder of the office ceases from a cause to be a director, and unless the agreement entered into in a particular case otherwise provides, the determination shall not constitute a breach of contract with the company. Now, if you're managing director, you are sort of standing in for the board of directors on day-to-day basis when they are not in the boardroom. You are supposed to exercise some of their powers, and even sometimes all their powers in relation to certain transactions. And so what that means is that you must have your directorship active. Your directorship should be intact. Shareholders should not have removed you as a director. If you are removed as a director, then automatically the appointment that you were given as a managing director will also come to an end. Unless maybe in the constitution of the company, they have made some other arrangement. Or maybe when you are appointed, certain special arrangements were made. Otherwise, the general position is that if you are removed as a manager, as a director, then your employment as a managing director will also be determined, or will also terminate, so to speak. And see, directors may entrust to and confer on managing director any of the powers exercisable by them on terms and with the restrictions that the director think fit, and collaterally with or to the exclusion of the powers of the directors and subject to the terms of an agreement entered into in a particular case, may from time to time revoke or vary all or any of those powers. Yeah, so as I explained, that the managing director, you are given powers which are usually exercised by the board collectively. But they entrust that to you. And instead of the whole board coming to meet and decide, you are given the power to decide. You are given power to enter into certain transactions and all that. Yeah, so in a nutshell, this will end our discussion of the types of directors, unless there are questions about what we've just discussed. Otherwise, we draw the curtain down and then we meet.
So I have a question.
Okay.
Sir.
Yes, go ahead, please.
Yeah, my question is about an alternative director.
Okay.
We said, or we learned that a director can also appoint another director as an alternative director.
Yes.
If it happens so, is it a proxy? So when it's voting, you can vote two, or it is not the case?
All right, thank you. Yeah, so where you are a director, that is to say that you're already part of the board of directors, and a colleague director appoints you as the alternate director. You have, if you like, two voting rights. You have your own voting right as a director in your own right. And then the other person who has appointed you alternate director, you also have his voting right. So you vote twice.
Thank you,
Okay.
sir.
All right.
Thank you, sir.
You're welcome. Okay. Have a good night.